the Labor Department revived 17 opinion letters to employers issued during the final days of George W. Bush's second term, a move that represents a shift in how the department will enforce compliance with overtime and other wage requirements. The letters from the Wage and Hour Division, which were withdrawn once Barack Obama took office, provide interpretations of how the Fair Labor Standards Act applies in individual cases. The Obama administration stopped issuing these letters altogether, instead releasing broader administrators' interpretations that laid out how the department viewed employers' specific obligations under the law. Businesses and labor advocates have sparred over how best to provide guidance on these issues for a decade. The National Association of Manufacturers and the U.S. Chamber of Commerce welcomed the Trump administration's move, saying it revives a narrowly tailored approach that does not establish new legal precedent. Critics said these individual letters allow employers to skirt paying overtime and complying with other aspects of the far-reaching labor law. The administration is evaluating other aspects of how to interpret the FSLA, which covers everything from child labor to record keeping. On Friday, the Labor Department announced it was changing the way it evaluates whether interns and students qualify as employees under the 1938 law, to better reflect recent court rulings. Mark Friedman, Executive Director of Labor Law Policy at the U.S. Chamber of Commerce, said in an interview that the revived approach was a far superior way for employers to provide specific advice on compliance questions than the sort of broad pronouncements from on high issued through such interpretations. These pronouncements were made with no public involvement, no public engagement, Friedman said. National Employment Law Project Executive Director Christine Owens, however, blasted the revival of the 9-year-old letters as another example of how this administration is siding with big business to make it harder to get paid for working overtime and to make it easier for companies to reap the benefits of young workers' labor without paying a cent for it. David Vey, who served as Wage and Hour Administrator under Obama, said in an email that opinion letters are problematic because they take considerable time and effort to craft, yet only address one company's situation. In the past they have been used as get-out-of-jail-free cards by some companies and create uneven patterns of expectations among employers, he said, adding that the interpretations he issued while in the job were more comprehensive. If Labor Secretary Alexander Acosta reverts to opinion letters, Vey added, I would hope they provide the public transparency on who has requested them, and that workers and their representatives be allowed to make the same sort of requests. The letters in question were all posted online in January 2009, but they were never mailed. Obama officials rescinded them immediately upon taking office. In a similar vein, Acosta withdrew in June 2 of the most controversial administrators' interpretations issued under the Obama administration.